Citizens, scribblers, professional victims, let me ask you a very simple question. Have you ever noticed that some people do not just lose lawsuits, they lose them repeatedly? Here are the 7 fatal errors to avoid.
Some people lose or dismiss most of their cases. In different courts, in different states, in different years, and against different people. And yet, somehow, every single time, it is still a conspiracy. The judge was biased. The clerk was corrupt. The lawyer was incompetent. The system is rigged. Reality is fake. And the one thing that is never wrong is their case. Today, I am going to show you something that many people apparently live their entire lives without ever learning. What a lawsuit actually is, how it actually moves, and where it is actually decided. And more importantly, where people go off the rails, light themselves on fire, and then accuse the fire of being unfair. Courts are not theaters. They are not confession booths. They are not truth-seeking adventures. They are machines. And if you do not understand the machine will eat your story and not even burp. Today, I am going to show you the machine, piece by piece, and where people usually put their hands into it. Let us begin. What a lawsuit is. First, we must destroy a very popular fantasy. A lawsuit is not a quest for truth. It is not a moral reckoning. It is not a public investigation. It is not a documentary. And it is not a performance. A lawsuit is a formal, rule-bound procedure for resolving a specific and narrow dispute between specific parties, using admissible evidence under strict procedural constraints. That sounds boring. It is. And that is exactly why so many people fail. They show up with a story, a narrative, a folder of screenshots, a lifetime of grievances, and a deep emotional need to be validated. And the court says no. Not because the court is cruel, and not because the court is corrupt, but because the court is a machine. You do not put soup in a toaster. You do not put vibes in a courtroom. Courts do not run on feelings. They do not run on fairness. They do not run on outrage. They run on procedure. They run on burden. They run on evidence. And they run on rules. Anything that does not fit through those filters simply disappears. This is why people feel ignored. They are not being ignored. The system is not asking who is right in some cosmic sense. It is asking whether a claim fits inside the rules it is allowed to apply. If it does, it moves. If it does not, it stops. If you remember nothing else from this video, remember this. You are not entering a story contest. You are entering a processing system. And systems do not care how meaningful your story feels to you. They always choose rules first. Step 1. The complaint. Every lawsuit begins with a document called a complaint. This is not your autobiography. And it is not your complete history with the other person. It is a structured legal document that alleges specific legal claims based on specific facts and asks for specific relief. This is where many people commit the first fatal error. They confuse telling a story with pleading a case. The court does not care that someone is a bad person. The court does not care that someone is a liar. The court does not care that someone ruined your life. The court cares whether specific legal elements can be proven. Who did what, when they did it, how it violates the law, and what evidence will support that claim. A complaint is not graded on passion. It is graded on structure. It is graded on jurisdiction. It is graded on whether the required elements are actually alleged in a way the court is allowed to process. If your complaint is long, emotional, vague, narrative, or chaotic, you are not telling the court a story. You are telling the court that you do not understand what it is. Many people believe that if they include everything, somewhere inside that mountain of material, the truth will shine through. Courts do not work that way. Courts are not panning for gold. They are checking whether you brought the correct metal in the correct shape. If you do not plead elements, Your case can be dismissed even if your story is true. That is not unfair. That is how the system works. This is also where people misunderstand what dismissal means. A dismissal is not the court saying nothing bad happened. It is the court saying you did not present it in a legally usable form. This is why so many cases begin to die before they ever truly start. Not because the facts are weak, but because the structure is wrong. And once the structure is wrong, everything built on top of it becomes unstable. Step 2. Motions. After the complaint is filed, the defendant usually does something very simple. They try to kill the case immediately. This is done through motions to dismiss, motions to strike, or motions for judgment on the pleadings. These motions do not argue about evidence. They argue about structure. This is where many people become confused. They expect the other side to deny facts. Instead, the other side attacks the shape of the case itself. The motion says something much more brutal. It says, even if everything you said is true, this still does not add up to a legal claim. This is where the second fatal error appears. People say, they did not even deny my facts, so I must be winning. No, they are saying your facts do not matter, because they do not legally connect to the result you are asking for. And many cases die right here. No discovery, no trial, no dramatic confrontation, just dismissed. That is correct, because evidence comes later. Motions test whether the case belongs in court at all. They test jurisdiction, sufficiency, and legal coherence. They do not test who is more believable. They do not test who is more sympathetic. They test whether the rules allow the case to continue. This is also where many people start inventing motives. They assume the judge must be biased or the system must be corrupt, because surely no one could reject something so obviously important. But courts do not measure importance. They measure sufficiency. If your case cannot survive this stage, it does not mean nothing bad happened. It means you did not present it in a legally usable form. That is not a conspiracy. That is a filter, doing exactly what it was designed to do. Step 3. Discovery. If your case survives the motion stage, you enter discovery. This is where documents are demanded, questions are asked under oath, and witnesses are examined before trial. This is also where many people experience their first serious collision with reality. This is where the third fatal error appears. Discovery is a controlled, limited, rule-governed exchange of information. Its purpose is not to tell your story. Its purpose is to test whether your story survives contact with documents and sworn testimony. Discovery punishes exaggeration. It punishes contradiction. It punishes improvisation. People who have been freelancing their facts for years often meet paperwork here for the first time, and paperwork is not sentimental. Many people damage their own cases by talking too much. They volunteer explanations. They attach essays. They provide context nobody asked for. They try to be persuasive instead of precise. Every answer becomes evidence. Every inconsistency becomes ammunition. Every unnecessary speech becomes a liability. Strong cases usually become clearer in discovery. Weak cases start to bend. Fantasy cases often begin to collapse completely. This is not because the other side is clever. It is because reality is stubborn. Discovery is also where many people first realize that the court is not interested in how offended they feel or how unfair the situation seems. The court is interested in what can be proven, what can be shown, and what can be tied to actual claims. If you cannot support your allegations with documents, testimony, or admissible evidence, discovery will expose that. If you can, discovery will strengthen your position. This phase is not glamorous. It is slow. It is technical. It is frustrating. But it is where most cases are truly decided, long before anyone ever walks into a courtroom for trial. Step 4. Summary judgment. After discovery, someone usually files a motion for summary judgment. This is the quiet execution. It says we do not need a trial. because there is no genuine dispute about material facts. A court is not saying nobody did anything wrong. The court is saying that, based on the record that exists, no reasonable fact finder could rule the other way. This is where the fourth fatal error appears. People say the other side is afraid to go to trial. No, they are saying your evidence is not enough. They are saying that even if everything is viewed in the light most favorable to you, you still lose. Many cases end here, not with drama, not with speeches, with a ruling on paper. Summary judgment enforces a boundary. Trials exist to resolve real factual disputes, not to rehearse arguments that already failed. If discovery shows that documents, testimony, and admissions line up in only one direction, there is nothing left for a jury to decide. The judge does not weigh credibility here. The judge checks whether a real dispute exists. This moment often shocks people who expected a public reckoning. They wanted a day in court. They wanted a story to be heard. But courts are not theaters. They are filters. They remove cases that cannot win under the rules. When a case ends at this stage, it is not because someone was silenced. It is because the system concluded that, under the standards that govern, there is nothing left to resolve. That is not cowardice. That is efficiency, and it is how limited courts keep moving. It also prevents resources from being consumed by disputes that cannot ever succeed here. Step 5. Trial. Only a small percentage of cases ever reach trial. Trial is expensive, narrow, boring, and tightly controlled. By the time a case gets here, most issues have already been filtered out by motions and discovery. What remains is not a story, but a set of specific questions. The judge controls the boundaries, and the rules control the questions. The clock controls everything. This is not a performance. It is proof. This is where the fifth fatal error appears. People think trial is their moment to finally tell their story. It is not. You do not get to show everything. You do not get to educate the jury about your entire life. You get questions, objections, and limits. That is all you get. Every exhibit must be admitted, every witness limited, and every issue tied to the pleadings. That is not censorship. That is structure. The courtroom is designed to reduce noise, not amplify it. If something does not fit the rules of evidence, it does not exist for the jury. Preparation matters. Passion does not here ever. Trial is not about who is more convincing. It is about who met the burden under the rules. When people lose here, they often feel unheard. They were not unheard. They were constrained. That constraint is the point. It keeps the decision narrow, reviewable, and predictable. And it prevents the courtroom from becoming a stage for speeches ever. Step 6. Appeal. If you lose, you may appeal. Appeal is not a new trial. It is not a do-over, and it is not a second chance to explain what really happened. It is a review of legal errors committed by the lower court, using the record that already exists. No new witnesses appear. No new exhibits arrive. No new stories are told. This is where the sixth fatal error appears. People think, now I can finally show them the truth. The appellate court does not care about that. It asks only whether the trial court applied the law correctly and whether the procedures were followed. Appellate judges do not reweigh evidence. They do not judge credibility. They do not decide who seems more sincere. They look at rulings, standards, and instructions, and they decide whether a mistake happened that actually mattered. If the law was applied correctly, the answer is affirmed. If an error occurred, the case may be reversed, or sent back, or corrected. None of that is a victory lap. Appeal is about rules, not feelings. It is slow, technical, and narrow. Many people file appeals because they are angry, not because there is a real issue. That usually ends the same way. That is all it ever reviews. Step 7. Finality. Eventually, the system says stop. This is the point called finality. It is not a suggestion. It is not a pause. It is the system declaring that the dispute has been resolved as far as the rules allow. This is where the seventh fatal error appears. Some people cannot accept finality. They believe persistence is virtue, repetition is strength, and refusal to stop is proof of righteousness. In court, those beliefs are liabilities. When a case ends, the court expects compliance. Instead, some people refile the same claims in new forms. They rename arguments. They accuse judges of bias. They claim conspiracies. They insist the system must listen again. Courts respond predictably. First comes dismissal, then warnings, then sanctions, then filing restrictions. The response escalates not because the claims improve, but because the behavior worsens. At this stage, the problem is no longer the original dispute. The problem is the litigant. The court is no longer resolving a case. It is managing a pattern. Finality exists, so disputes end. It protects defendants from endless harassment. It protects courts from endless noise. And it protects the system from becoming a theater for obsession. People who refuse finality often believe they are fighting corruption. In reality, they do not understand the machine, where people self-destruct. Let us list the ways people destroy their own cases. Not by accident, not by mystery, and not by conspiracy, but by predictable, repeatable behavior that shows up in courtrooms every day. First, they treat the complaint like a story instead of a pleading. They write novels, manifestos, and diaries, and they forget to allege elements. The court grades on structure, jurisdiction, and sufficiency. Second, they do not understand motions. When the other side files a motion to dismiss, they argue facts instead of defects. When the other side files a motion to strike, they deliver speeches instead of fixes. They celebrate when nothing is denied, and they panic when nothing is granted, and they miss what the motion is actually testing. Third, they use discovery like therapy. They answer questions with context, attach essays, volunteer speeches, and reveal contradictions that did not need to exist. Discovery is not there to heal you. Fourth, they confuse narrative with evidence. They think that a screenshot proves intent, that a timeline proves causation, and that repetition proves truth. Evidence must be admissible, relevant, authenticated, and tied to elements. Stories do not satisfy burdens. Fifth, they treat trial like a stage. They plan speeches, not proofs. They expect applause, not objections. They are shocked when the judge limits questions, excludes exhibits, and keeps the case narrow. Sixth, they treat appeal like a do-over. They rewrite history, re-argue credibility, and submit new material that the court cannot consider. Appeals courts review rulings, not feelings. Seventh, and most dangerous, they refuse to accept finality. They refile in new forms, rename the same claims, and accuse everyone of bias when the answer stays the same. At this point, they stop being a party and become a pattern. All of these failures share one cause. They never learned what the machine is. Courts do not exist to validate identity. They exist to process disputes. The inputs are pleadings, motions, evidence, and rules. The outputs are orders. If you bring stories, the machine filters them. If you bring speeches, the machine trims them. If you bring rage, the machine ignores it. And if you bring persistence without correction, the machine escalates consequences. So if you want to know where cases really die, it is not in secret meetings and not in shadowy backrooms. They die in filings. They die in deadlines. They die in misunderstandings that never get fixed. Learn the machine, or the machine will teach you, and its lessons are written in orders. Closing arguments. The takeaway. So citizen, if you are thinking about court or watching someone else spiral through it, remember this. Courts do not run on stories. They do not run on outrage. They do not run on how strongly someone feels. They run on rules, and they run on procedure. If you bring a story to a machine that eats documents, do not be surprised when your story disappears. If you bring speeches to a system that filters filings, do not be surprised when the speeches are ignored. Courts do not exist to validate identity. They do not exist to resolve moral narratives. They exist to process disputes inside a very narrow and very rigid framework. That framework can feel cold. It can feel unfair. It can feel indifferent. But it is the only thing that makes decisions predictable, reviewable, and final. Process beats passion. Always.
Learn the process, work inside it. Avoid the fatal errors. Many people believe they are fighting the system. In reality, they are not understanding it. I am Polemopicus, and Caesar demands that the rules are followed.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.